Before starting the discussion, let us know the literal meaning of the two words. 1. Clog and 2. Redemption. Clog means to hinder or obstruct or to become blocked. And redemption means recovery or an action of regaining the possession. Then the question arose, what is right of redemption? When the borrower or mortgagor repays his loan amount along with the interest, if any, to the lender or mortgagee, there arises the right of getting back of his property from the mortgagee's custody. Such right of getting back is the right of redemption. And when there is an obstruction or blockage comes in the way of regaining or returning back of the property is the clog on redemption. In other words, the restriction upon the mortgagor to redeem. The clog on redemption is a doctrine in the matter of mortgage. In mortgage, there are two parties. One from whom the property is moved for receiving loans is called the mortgagor, and one who lend or forward the loan is called the mortgagee, and the instrument in which the terms and condition of mortgage is written down is called the mortgage deed. The doctrine of clog on redemption is dealt in section 60 of the Transfer of Property Act 1882. The concept of clog on redemption can be marked during the Roman law and in the Anglo-Saxon period in England. The doctrine is based on justice, equity, and good conscience, and developed in the English court in Stanley versus Wilde. There is well-known maxim in the court of equity that once a mortgage is always a mortgage. There are certain situations when the doctrine of clog on redemption comes into play. 1. Long-term mortgage. If the tenure of the mortgage is for a very long time, such as equal or above the normal human lifespan, say for 99 years or 999 years, that is a clog on redemption. We see the 30 years duration mortgage deed. That is not a clog on redemption. The underlying factor is that if the tenure restricts the mortgagor from regaining the property during his lifetime, is the clog on redemption. 2. Condition of sale in default. If the mortgage deed, a condition is set forth. On default of the repayment of loan, the mortgage property will goes in favor of the mortgagee in form of sale. That is a clog on redemption. 3. Collateral benefit to the mortgagee. Mortgagee gains some collateral benefits under the mortgage deed, such in case of usufruct mortgage. If the collateral benefit continue after the repayment of loan or after the end of the mortgage deed period, and such is in the clause under the mortgage deed, then there is a clog on redemption. 4. Penalty for default. In a mortgage, the rational penalty is allowed for default, but the abnormal or irrational penalty in a compounding form or nature is not allowed. High interest does not constitute clog, but the dominating factor acts as a clog. 5. Alienation of property. If in the mortgage deed a clause restricting the mortgagor to alienate his property in form of gift or sale is a clog on redemption. During the existence of the mortgage, if the mortgagor wants to gift his property, the mortgagor can do so under section 128 of the Transfer of Property Act. The objective of this doctrine is that the mortgagor have the equitable right of regaining the property on repayment of loan, and the mortgagee cannot restrict the same. So, a mortgage always a mortgage, and the nature and character of the instrument cannot be changed. The mortgagor have every right to settle the loan by repayment of all, including the interest if any, and the mortgagee cannot restrict it. Let us have some case reference. 1. Vadilal Chhaganlal versus Golokdas Manshuk, Bombay High Court, 1953. 2. Haji Fatema versus Prahlad Singh, Madhya Pradesh High Court, 1985. Parmeshwaran Govindan versus Krishnan Bhaskaran, Supreme Court, 1992. 4. U. Nilan versus Kannayan through legal representatives. Supreme Court, 1999.